the personnel file disclosure issue was far more calculated and well thought out than the Class C arrest issue. So originally, Representative Moody had filed House Bill 147, which was advertised and presented as a means to give the families who had lost a loved one in police custody access to that last footage before their loved one died.
When in fact, the entire premise was to get at exposing the G file to the public, to the media, and particularly to criminal defense attorneys.
Civil Service has a personnel file section, 143089G, and is usually referred to as the G file, that keeps department maintained records secret. And the only thing that is accessible is what is in your permanent civil service file. The Department G file is not generally open to the public. And so this bill would do that and allow alleged misconduct, misconduct that hadn't been investigated, misconduct that had only been alleged and had not been sustained or substantiated from being released. And we had a real problem with that. And so we voiced our concerns to Representative Moody, and we testified against the bill when it was considered by the House State Affairs Committee.
Which, in committee it was a gut-wrenching, just hours of testimony from families who had lost their loved ones. It was sad, it was emotional, and it was hard to argue with the fact that these families should be able to see these final few minutes of their loved one's life. However, tacked onto the bottom of that bill that was not addressed by the author, it was not mentioned by anybody who was testifying for the bill, was the exemption of personnel files from the Public Information Act. So currently they're protected, but under this bill, this kind of almost a sneaky clause that was put in there would have allowed those to be accessed through a public information request.
We offered to work with them. We had no problem if a family wanted to view a video or view some evidence to get some closure to themselves. What we had a problem with was too early in the investigation, it being released out to everyone else in the world, and people start making judgments without all the facts being collected and without it being looked at in a methodical manner.
We remained opposed during the hearing. Some of the other groups changed their positions. And we have found that if you do that and they don't do what they said that they would do, then you're stuck with your position.
We were the only police group that stayed off the bill.
My name is Ray Hunt. I'm the past president of the Houston Police Officers Union.
Representatives, my name is Shredder Frazier. I represent the Dallas Police Association and now the Fraternal Order of Police for the state.
My name is Jessica Anderson. I'm with the Houston Police Department.
Chairman, you may change me to on now.
I'm on the bill.
On the bill, okay.
Yeah.
Registered opposed to the bill. I'd like to change that to on.
Our position, our core value did change. Our belief that families should have closure, our belief they should be able to see the final moments or anything, even if it's painful for them, we were okay with that.
So we remained opposed with the caveat that if we were able to work out some language with the author, we could change that at a later date. The author said he was going to address the civil service or the internal affairs issue in the hearing. He also said he was going to address an issue about a video of an officer who was killed in the line of duty.
We continued to try to work with this legislator to find common ground.
We told Representative Moody's staff that we were not supportive of the substitute, and if you wanted to change the bill to deal with the video issue, we would support something like that. They wrote back and said, well, no, that's not their main reason. The families are not their main concern. Their main concern is getting access to the information on officers.
Which is when we said, okay, we're out.
We're not going to communicate anymore. We can't reach an agreement, and that's normal. That's no different than any other advocacy group taking a position of not supporting a certain piece of legislation, yet we got castigated by the author as being dishonest and untruthful on how we characterized this bill, which was not the case. So we remained opposed, and what happened was the author found a vehicle to stick his language on later in the game, and that was Senate Bill 944, which was a general open records bill that was brought over from the Senate and brought to the House floor, and Representative Moody offered an amendment to do what 147 was going to do to that bill. Once that happened, and once it got put on, because it happened quick and without warning, we activated our lobby team in opposition to that amendment. And that meant that we worked the Senate in opposition, we worked the governor's office.
And we worked with Doc Anderson on getting something done that would help the families.
Because we did that, of course, some folks took that personal, and instead of talking about the issue and our position on the issue, they attacked us in the media and on the floor of the House.
Those portray those things to us erroneously, falsely, knowingly, willingly, misleading us. Those were the things that were the most dangerous and the most difficult for us to defeat.